And welcome, and thank you, John. We couldn't do without the support of the Jones Day Foundation. We wouldn't be here this evening, either in person or online, if it weren't for you supporting this venture. I'm Sarah Worthington. I'm a fellow at the British Academy, and the British Academy, together with the Bingham Centre and Murray Hunt, who is the director of the Bingham Centre, are delighted to welcome you here. We two institutions make it our business to facilitate discussion of challenging issues, and tonight's discussion on the rule of law and the future of democracy certainly fits that description perfectly. The topic is a serious one, and it raises a number of really difficult issues, as I suppose all foundational matters do. Tonight's discussion was prompted by Sir Jack Beatson's latest book, The Rule of Law and the Separation of Powers, and I know copies are on sale here this evening, but this isn't a book launch, or it isn't simply a book launch. As John said, recent events going from Brexit to the approach taken to dealing with COVID, and I guess the talks of reforms to the Judicial Review Act, have all really focused our minds, or refocused our minds, on the role of the rule of law and the future of democracy. Our unwritten constitution and the respective powers and competencies of the legislature, the executive and the judiciary have sort of held together for hundreds of years, sometimes under pressure, I suppose. But now those important relationships between the three branches are being subjected to quite unusual stresses. And this evening's discussion, we hope, will explore some of those matters. And for that reason, it's my enormous pleasure to chair this event. We're going to start with a discussion led by the speakers that will last for about 35 or 40 minutes. And of course, none of the speakers needs any introduction, and yet chairs always introduce them. But I know that you're all here precisely because you do know who these people are, and you've come because you want to hear what they have to say. So I am going to get on with the main act. We're going to proceed like this. Sir Jack Beatson will introduce the discussion. He's going to talk for about 5 minutes on his goals in writing the book on the subject. Jack's a fellow of the British Academy and now a full-time arbitrator. But before that, he was a judge in the Supreme Court, a law commissioner, in the Court of Appeal, the Court of Appeal. Promoting you without cause. And the Rouse Ball Professor of English Law at the University of Cambridge, and an author, of course. And then he's followed by Lord Sales, who is in the Supreme Court, and also a rather prolific writer himself. When Lord Sales was still, not Lord Sales, but Sir Philip Sales, and in the Court of Appeal, he was one of those three judges on the infamous cover of the Daily Mail headlined "The Enemies of the People." And so Philip's going to use Jack's book, but only as a starting point to speak more broadly about the issues in play, especially from the perspective of a judge and before that a practicing lawyer. And then our third speaker is Professor Aileen Kavanagh, who's the Professor of Constitutional Governance at Trinity College in Dublin, and formerly the Professor of Constitutional Law at the University of Oxford. Aileen, this only emerged late yesterday, is joining us remotely. And we're now all used to the reason. One of her family members was in contact with someone with COVID, so now the whole family has to await tests. But welcome, Aileen, remotely. We'll get to see her and her lovely background shortly. Then we're going to return to Jack, who will have 5 minutes to both respond and expand on what's been said. And I hope what that means is that we'll have had 35 to 40 minutes from three people who are each in quite different ways really eminently qualified to speak on the subject of the rule of law and the future of democracy. And that introduction, I hope, will inform and help you gather your thoughts before we hand over to you for discussion and Q&A, both from the floor here in the British Academy and online. We had over 600 people sign up online, so if they all want to ask questions, we won't be going through every one of them. But can I remind you in that vein that this is being recorded, live streamed and recorded, and the three main speeches from our speakers will then be put up on the website for both the Bingham Centre and the British Academy later on. But without more ado, I hand over to you, Jack. Sorry to promote you.
It's all right. Oops. The big debate was whether to do this sitting down or standing up. And I've decided to stand up because I can appear to be not reading as much as I would be if I didn't have the lectern. Not surprisingly, given my background, my short book, and it is very difficult to write a short book, I could tell you, gives a court-based lawyer perspective on the rule of law in our parliamentary democracy and the respective roles and limits of law and politics. And I believe that circumspection is something which is due not only from serving judges, but also from former judges. So I haven't become a civil libertarian any more than I was when I was a judge. The book, I had three aims with the book, and I wanted to give three messages. In a nutshell, they can all be summed up by the words of the late Neil McCormick in his 2006 British Academy Law lecture. Quote, "The Constitution does not belong to the executive of the moment." So the three aims. The first one is to discuss what's involved in the rule of law and to try to answer the charge that it's hopelessly uncertain. In my account, it has four components: the subjection of all, including government, to law, equality before the law, secondly, accessibility of law, prevention of arbitrariness, and reasonable certainty and stability, which may all be different ways of saying the same thing. Thirdly, access to justice before independent and impartial courts. And fourthly, the conformity of and this is the trickiest part, the conformity of the law to certain fundamental values or substantive ideals. It's a way of balancing the need for a democracy to enable majorities who are put into office by the people with the need to protect the fundamental rights of minorities, including the present majority who may be a minority sometime. And the third aim, which I'm not going to say very much about because most of you seem to be lawyers, is to consider the particular dangers of trying to restrict and attempting to restrict access to the ordinary courts. My three messages are: message one, the subtle and complex arrangements we've had over the last 60 years generally provide the safeguards that all say they want. Most importantly, because they rely on principles of interpretation rather than rules, they have done so without imperiling the proper balance and the primacy of the democratically accountable parts of government. Two commentators have said that the courts have been the guardians, not the guarantors of civil liberties. Some people say they haven't been either, but and some people say that they overstretched. But what I seek to do is to try to describe the way our arrangements promote the values inherent in the rule of law and the separation of powers, and to illustrate with examples, I can't give them to you, there are plenty of copies of the book out there, the areas into which judges should not go and generally do not venture, or about which they should be particularly cautious. That's message one. Message two follows from message one. The courts must not overreach themselves. If they do, as Lord Scarman warned as long ago as 1980, they will make society ready for Parliament to cut the power of the judges, with the result, quote Lord Scarman, the power of the judges to do justice will become more restricted by law than it need be or than it is. Anyway, in regard to that, I don't believe I'm what is now called a judicial power merchant by those who think the judges have overstepped. I recognize the undoubted need for the executive to be able to exercise power effectively, efficiently, and in Blackstone's words, with dispatch. For example, and there are many more in the book, I recognize that despite the serious strains of closed material procedures which deal mainly with national security issues, besides the strains of those on rule of law values, such procedures may be justifiable if adequate alternative safeguards are provided. Although one member of those in this room have said that trying to square the two is to try to balance the impossible. See Bellhatch. The argument, the third message is, going back to where I started, the argument that there's been judicial overreaching and that the political accountability of the executive to the legislature provides our democracy with adequate safeguards does not reflect the reality of the way the modern executive operates in the United Kingdom. Lord Scarman may have exaggerated in a 1989 lecture, I think after he'd retired, where he said, "We have achieved the total union of executive and legislative power, which Blackstone foresaw would be productive of tyranny." Well, I don't think we've quite done that. But, and I want to leave aside current things that everybody's been reading about or listening to, we do have prime ministerial government. We have, and we can see the apparent ineffectiveness of the elected chamber, even on issues where many government MPs disagree or are uneasy with the government's approach. There is a very large proportion of the members of parliament on the government side hold ministerial offices of various ranks. And so they're part of the team. We have a second legislative chamber, which understandably and justifiably, because it's not elected, has a subordinate status. But most importantly, we've seen increased willingness of the executive to bypass Parliament, notably in the fact scenarios that led to the two notable constitutional cases, Miller 1 and Miller 2 and Cherry. Other examples of bypassing Parliament are to govern by non-binding and confusing guidance. Perhaps that's what you were referring to. By the wide use of what are called Henry VIII clauses, giving ministers power to amend or even repeal acts of Parliament with little or no parliamentary scrutiny. And by trying to develop and make policies by announcements at press conferences, which we're all then expected to follow. The recent willingness, apparent willingness, to break international agreements, as seen in the Internal Markets Bill in 2020, and to justify non-compliance with statutory requirements, as one Secretary of State did in relation to procuring PPE equipment during the pandemic, are particularly troubling, as is that Secretary of State's reaction to the case which said that he'd acted unlawfully, which was, well, I was more interested in saving lives. But of course, we're all interested in saving lives. Given what Neville Johnson called the fundamental imbalance between the legislature and the executive, and political scientists have written a lot about this. Peter Hennessy, for example, and Werner Bogdanov, but particularly Neville Johnson. Just as the courts mustn't overreach themselves, it's very important for the executive not to overreach itself. Executive power must be exercised with the self-restraint which constitutes one of the essential underpinnings of democracy and the rule of law. And we've done it over our history with constitutional conventions. The question mark about whether we're less interested in constitutional conventions. Many commentators, non-lawyers, have argued that the executive's own internal controls and self-restraint have been seriously weakened over the last 35 years. It's not an issue about what's been going on in the last 2 years. It's all been bubbling away quietly. So I conclude with, again, Neil McCormick. In the same lecture, he said, although governments have indeed the right to legislative initiative and are entitled to achieve programs of reform for which they have a reasonable electoral mandate, there should be considerable caution and a wider view when it comes to revising constitutional fundamentals. And those considering changes, whether they're the ones before Parliament now or the ones that will be coming before Parliament once the Secretary of State for Justice has considered Sir Peter Gross's report and decided whether to go with it or to go with something else, they should bear this in mind. Compare the wide consultation before the Human Rights Act was enacted and the referendums before the devolution settlements. So I try in a very short space to tease these issues out. I think it's time for me to hand over to Lord Sales.
Good evening, everyone. The title of Jack's book, The Rule of Law and the Separation of Powers, seemed at first to involve a curious juxtaposition of different concepts. But I think he makes a good case to show that each resonates with the other. The treatment in the book reveals a court-based lawyer's perspective on key aspects of the UK's constitution. I think it is a great strength of the book that it draws together threads from both common law and human rights law to address these concepts in a structured way. In our pre-discussion between the three of us, the three speakers, I was struck by a comment by Aileen that the rhetoric of rule of law is far more muted in Ireland, probably because of its written constitution. By contrast, the courts in the UK resort to the language of rule of law and separation of powers to legitimise and explain their constitutional role, and also the constitutional role of others. They do this facing in different directions in different contexts to delimit the role of courts as against the legislature, courts as against the political executive, courts as against specialised executive agencies, and executive as against legislature, as in Miller 2. In one sense, the court's role under the rule of law is uncontroversial. They apply the law. But the key question is, how do you identify the law to apply? Both the Miller decisions illustrate the court's grappling with this. To answer the question, two important interrelated issues have to be addressed. First, to what extent is the concept of the rule of law substantive? And second, what is the role of the courts in identifying what the law is? This involves separation of powers issues of courts as against the legislature, and separation of powers issues regarding the court's role in supervising executive action to determine the relative decision-making authority of the courts and the executive. Under the first question, the role of the courts has fluctuated somewhat over time, depending on whether they have conceived of themselves as simply fulfilling a faithful agent function to give effect to law as written by Parliament, or as, to some degree, guardians of deeper constitutional rights and principles which are taken to inform and modify the written text of a statute. It's fair to say that from the 1960s onwards, the courts have been more willing in the developed administrative state to inject a form of rule of law morality of the Lon Fuller type into their interpretation of statutes. It is this sort of morality which seems to me to infuse Jack's account. Law should be accessible, not retroactive, and so on. This trend developed further in the last decade of the 20th century into a more explicit protection of individual rights, identified by the courts and labelled by them as fundamental, through a doctrine called the principle of legality, and then through the adoption into domestic law by the Human Rights Act of express positive rights in the European Convention on Human Rights. Through interpretation of legislation, the courts try to balance the two principles which underpin liberal democracies, the democratic principle and the rule of law or human rights principle. On one view of the first Miller decision, the two principles ran together, whereas critics of the decision thought they were in tension. In a resonant phrase, Spinoza said that the meaning of the state is freedom. This implies that the law the state lays down must be accessible and comprehensible to citizens, and Jack addresses this in chapters 4 and 5 of his book, and that they must be able to have access to courts to enforce the law, which Jack addresses in chapter 6. Under the second of the questions I've mentioned, the courts have to explain, carve out, and delimit their role against that of other agencies of the state. Separation of powers tends to be the framework in which they seek to do this. Separation of powers has gone up the legal agenda and has also become more finely tuned over time, say the last 60 years or so. This is partly a function of what Neville Johnson, in his book Reshaping the British Constitution, called the increased functional specialisation in the British state. A conception of specialised zones of policymaking by different agencies of the state has developed, and the courts have had to define where the boundaries are and then police them. This means the courts have had to address the boundary between law and politics, but also that between the courts, which use legal expertise, and specialist policymakers using other forms of expertise. On both boundaries, the Diceian concept of the rule of law as one set of rules for all has come under pressure to be replaced by the concept of the rule of law as appropriate demarcation to secure what Jack aptly calls the balance of responsibilities. The connection between the rule of law and the separation of powers is thus made central. Executive functions are parcelled up in different ways. They may be exercised by ministers, quasi-independent executive agencies, fully independent bodies like the Bank of England, or specialist bodies and tribunals such as the Competition and Markets Authority and the Competition Appeal Tribunal. Specialist bodies may take decisions which determine citizens' rights, but in order to respect their specialist role, the courts will generally only review their actions according to conventional judicial review standards. The landmark cases here are Bryan and the United Kingdom in Strasbourg and the Alconbury decision in this country. The application of human rights under the Human Rights Act and the principle of legality and the proportionality standard of review associated with those rights, and with the doctrine of legitimate expectation arising from government statements of policy, has drawn courts more into the realm of specification of policy. This has meant that the courts have had to articulate with greater care and specificity the proper limits of their role as against other agencies. Witness the Alconbury decision, for example, and the recent SC decision in the Supreme Court. Section 3 of the Human Rights Act has given the courts an enhanced interpretive role, as explained in Guyden and Mendoza, which is quasi-legislative. So the courts have had to explain how far they can go in modifying the meaning of legislation so as not to undermine the essence of the legislature's role. At the same time, the convention rights have authorised the courts to examine the quality of law laid down by Parliament or in subordinate legislation in terms of accessibility and clarity, according to the standards of law laid down in the case of Sunday Times in the United Kingdom. One could say that public law has increasingly come to be concerned with functional specialisation, and the response of the courts to this in the light of underlying constitutional principles of the rule of law and democracy, for which parliamentary sovereignty often stands as a cipher. Both have implications for the separation of powers, as a series of recent Supreme Court judgments illustrate. In the Majera decision, the court emphasised the obligation of the executive to obey a court order. In SC, the case on the 2-child limit for welfare entitlements, the court emphasised the width of the margin of appreciation for Parliament on matters of economic and social policy. In Shamima Begum, following the Raymond decision of the House of Lords, the court emphasised the responsibility of the executive for judgments about national security on grounds of democratic accountability and expertise. And in Privacy International, one sees the court divided, where there was a collision between different aspects of these principles. Chapter 7 of Jack's book contains a discussion of the independence and impartiality of the judiciary. This is, in a pure legal textbook, a novel, but in my view, valuable angle for a book otherwise directed to discussion of legal doctrine. In large part, the claims by the judiciary for their function in articulating the boundaries with other agencies are implicitly based on their independence and impartiality, so it makes sense for this topic to be addressed. However, this only helps to a limited degree to counter what can appear to be the overwhelming claims made by political agencies under the banner of democracy. The courts need to be able to point to substantive justifications for what they do, when that is in tension with the claims of other agencies. Jack rightly addresses this in chapter 9 of his book, entitled Enabling Majorities and Protecting Minorities in Our Democracy. It seems to me the courts have to be able to explain their role in democratic terms. The essence of a liberal democracy is that, using a slogan used by Jan Werner Müller in his book Democracy Rules, the majority should have their way after the minority have their say. The courts faithfully have to give effect to majority decisions as expressed in primary legislation. In doing so, they respect the equality of citizens and their representatives in a democracy to decide policy and what should be the law, according to the principle of one person, one vote. But at the same time, the courts need to be alert to protect the civil liberties and human rights which frame the sphere in which individuals live and form their opinions, and in which public opinion is debated and formed before being filtered through the political and legislative process to produce law. As John Dewey perceptively commented in 1927 in his book, The Public and Its Problems, I quote, "Majority rule, just as majority rule, is as foolish as its critics charge it with being, but it is never merely majority rule. As a practical politician, Samuel J. Tilden said a long time ago, the means by which a majority comes to be a majority is the most important thing. Antecedent debates, modification of views to meet the opinions of minorities, the relative satisfaction given to the latter by the fact that it has had a chance and that next time it may be successful in becoming a majority. The essential need, in other words, is the improvement of the methods and conditions of debate, discussion, and persuasion. That is the problem of the public." I end the quote. Perhaps it is this dual role of the courts as enablers of majorities and as protectors of individual and minority rights in the sphere in which majorities come to be formed, which allows one to speak of them as being, in some sense, one of the guardians of the Constitution. Thank you.
Now we need to switch to Professor Aileen Kaplan.
Hello, can you hear me?
Yes, yeah.
You can, right, great. Well, thank you so much to the Bingham Centre and the British Academy for inviting me to take part in this discussion this evening, and particularly to Professor Sarah Worthington and the team at the British Academy for facilitating my remote contribution. I'm very sorry I can't be there in person, but relieved and delighted that I can be there remotely. So it's a great opportunity and privilege to discuss this insightful and thought-provoking book by Sir Jack Beatson, which combines the merits of succinctness and sophistication. So it has admirable concision and contains compressed analysis in places, but it does not run shy of the complexities. Therefore, it is an ideal platform on which we can discuss the broader issues of the rule of law and the future of our democracy today. Now, when I finished reading Jack's book, I was left wanting more. And in particular, I was interested to know what Sir Jack's overall assessment was of the health of the British Constitution when assessed and measured against these two foundational principles, which he writes about in this book. After all, we know, as Professor Worthington said, that the British Constitution has been under a lot of stress lately for various reasons, both external and internal. One could say there have been some self-inflicted wounds and illnesses beyond its own control. But if we submitted the body politic to a rigorous health check in the 21st century, I am curious to know what your view would be, Jack, of what the overall diagnosis would be on the rule of law in the first quarter of the 21st century. And in asking for that overall assessment, I'm going to pursue the issue through three strands of analysis selected from a very rich book which covers the full swathe, in fact, of the British Constitution. And those three issues are, first, the role of the executive in the separation of powers. Second, the Human Rights Act, which is on many of our minds at the moment. And third, the small matter of the future of democracy. So starting first with the role of the executive in the separation of powers. Now, as Sir Jack presents it, the key rationale of the separation of powers is to provide checks and balances in a system in order to curb arbitrary power and prevent tyranny. So if we think about that as the locus of the separation of powers, checks and balances, what is our assessment of the role of the executive in the contemporary constitution? Now, I think it's open to two different narratives. One would be to say that we are living in an era of executive aggrandizement, which is creating a constitutional imbalance, as Sir Jack describes it, and is thwarting the meaningful political and legal checks within the system. So in recent times, we have seen the government trying to bypass Parliament in key political decisions, most dramatically, of course, in relation to Brexit. But we also have heavy reliance on delegated legislation and soft law to implement Brexit and to counter COVID. We have fierce criticism of the courts, which has stimulated reviews not only of administrative law jurisdiction of the courts, but also the Human Rights Act. And finally, there is some sense that the government is trying to curb or constrain the role of the independent civil service within the executive branch. So it's not just tackling the external separation of powers, that is between the executive and the other branches, but also the internal separation of powers within the executive itself. So one obvious diagnosis would be to say that we are facing an executive power project here, which is subsuming the constitutional system and undermining the checks and balances that were intended to constrain executive power. But another would say that actually, although the executive may have been straining against the constitutional leash and trying to aggrandize itself, it has not, in fact, succeeded. Boris Johnson, after all, did return to Parliament after the Miller decision. There has been, as Sir Jack puts it in his book, a new confidence in the common law jurisdiction of the courts and a flourishing in the principle of legality. But also, in recent years, we've seen some unprecedented flexing of parliamentary muscle as well. So this is another possible narrative that yes, the executive may have been trying to aggrandize and usurp and control the other branches, but in the British constitutional system today, it did not succeed in doing so. So my question under this heading to you and perhaps to the participants more broadly is, what is your diagnosis of the health of the checks and balances within the British constitutional system? Are they proving to be robust and resilient, or have they fallen away? Okay, the second topic I wanted to discuss concerns the Human Rights Act, which of course is on our minds, partly because of the Independent Human Rights Act review, and we await their report with great interest. Now, I was struck, Jack, by your description of the constitutional reforms post-1997 as a program for constitutional renewal. Some would describe that period as one of unprecedented constitutional change, and others would describe it as the death knell of the political constitution, with ire focused on the Human Rights Act in particular. Therefore, I was interested in perhaps further amplification of this comment you made, that you viewed this period as one of renewal. But looking a bit more closely at the Human Rights Act, how does it measure up against these principles of the rule of law and the separation of powers? In terms of the rule of law, of course, your answer may hinge on whether you support a formal conception or whether you embrace, as I think you do, a more full-bodied one, which includes the protection of rights and fundamental values. But throughout your very careful analysis of the principles of certainty, prospectivity, generality, and predictability, which, of course, no matter what you think the rule of law is, we agree at least on this. There are arguments that the Human Rights Act puts pressure on these values by allowing the courts to interpret legislation compatibly with rights. We may gain along the dimension of rights protection, but perhaps lose in terms of prospectivity and certainty. In terms of the separation of powers, you noted in your book the view of the Judicial Power Project that the Human Rights Act is a recipe for judicial overreach and perhaps an unashamed power grab by judicial ermine elites. If, as Lord Sales says, the judicial reasoning under the Act is quasi-legislative, then this seems problematic from a rule of law and separation of powers point of view. Now, I think this critique by the Judicial Power Project and others can definitely be met, and I am a supporter of the Human Rights Act and think that overall it has delivered good outcomes for rights and is not in contravention of the rule of law or the separation of powers. In mounting that argument and responding to the judicial power critique, I think there are rich resources in Sir Jack's book, particularly in his development of the theme of judicial circumspection. So he calls it judicial circumspection. And what he has in mind here is that judges may be given techniques of control, as he says, or tools of supervision over the other branches of government. But precisely because these are strong and powerful tools, Sir Jack urges courts to treat them with care. He gives many examples throughout the book, as did Lord Sales, of cases such as Bellinger, Nicklinson, El Ghazouli, and others. There are many where you see judges holding back from taking a more interventionist stance precisely out of respect and comity for the elected branches of government. So rather than it being a naked judicial power grab, I think the overview of the cases documented in this book bespeaks a more measured, nuanced, and calibrated approach, what I would call calibrated constitutional review, where judges seek to uphold the rule of law in a robust manner, whilst simultaneously remaining within the constraints of the separation of powers. So that's the Human Rights Act point. So finally, the rule of law and the future of democracy. When the topic for this seminar came up in my email inbox, I had assumed that the discussion would be on the global perspective. By any international measurement that tries to assess the rule of law and democracy in our time, it seems undeniable that we are living in a period of democratic decay and decline across Eastern Europe, Latin America, and of course within the Western democracies as well, not just the Trump legacy in America, but more broadly. We're experiencing democracy under pressure and the rule of law. So viewed from global perspective, the future of democracy may not look bright, but that global perspective simultaneously leads perhaps to a more positive assessment of the UK situation. In your book, Sir Jack, you quote Lord Hailsham's famous and much quoted phrase that the UK system and Westminster parliamentarism as elective dictatorship. Reading that phrase in 2021, I was struck by how accurate and apt it is to describe the populist authoritarian regimes in Eastern Europe, but how exaggerated it seems as a description of UK democracy. So I believe Lord Hailsham's phrase was, as you say, exaggerated for his time and exaggerated perhaps for effect. But I think it's especially exaggerated now, given the developments in Parliament since the 1970s. That includes the development of a robust select committee system within Parliament, including, in terms of the rule of law, the House of Lords Constitution Committee and the JCHR. There has been a strengthening of the House of Lords and a proliferation of NGOs and other civil society actors, including, of course, the Bingham Centre for the Rule of Law, and to some extent, as a knowledge institution, the British Academy as well. And we are very grateful for them for hosting these events, which shore up and seek to galvanize commitment to the rule of law. So the question arises when we look east, we look to Eastern Europe. What is it that they lack that we in the United Kingdom have? It isn't democratic elections. This is something these systems share with us. But what they lack is the discipline of democracy, acknowledging and accepting true counter-argument and opposition within Parliament, but also a commitment to the two principles you have singled out in your book, the rule of law and the separation of powers. I think this comparison emphasizes that these principles are cornerstones of any well-functioning constitutional democracy. And whilst we have worries in the United Kingdom about how they fare in current times, the broader perspective is also somewhat reassuring. So overall, if we submit the body politic to a constitutional MOT or a health checkup, the question is it doing well for its age, or does it need more exercise? Perhaps a little resistance training to strengthen constitutional muscles, which may not have been used as much as they should have in recent times. Or do we even need more radical surgical intervention to set the body politic on the right course? Whatever that course will be, I have no doubt that the principles of the rule of law and the separation of powers are integral and crucially important to that journey. I'm very grateful that Sir Jack has written this stimulating book so that we can explore those important principles further. Thank you.
Plan was that you would have 10 minutes if you want before we launch into discussion to respond and pick up ideas. Or less.
Well, I think it's quite important to hear I'm sorry. Yes, that was another reason I wanted to stand up earlier. I didn't have to, you know, I'm having to speak and hold a microphone. That's two things. It's quite difficult. I think what I'd like to do is just give a few comments on what Philip and Aileen have said. I think my great example of this recognition of specialisms and the difficulties of the court in dealing with technical, complex economic issues, et cetera, is the South Yorkshire case, in which the House of Lords thought that the Monopolies Commission had made an error of law in approaching the meaning of what a substantial part of the United Kingdom was, but nevertheless said, we're not going to interfere unless it's the sort of decision, because this is a complex economic matter and we're mere lawyers. Lord Mustell didn't put it like that. We're not going to interfere. So there was a margin of error. It is actually, in a way, as I think I've said to Philip Salesworth, it's the nearest thing we come to a sort of Chevron doctrine, where you leave the specialist regulator with a wide margin. So I think there's a lot of mileage in that theme that you took. But my other comments are really on Aileen's. I give a health check. Well, as I'm not becoming a legislator or a legislative drafter in my retirement, what I will say is that I think there have been strains, because I think people have tried to take shortcuts sometimes. Sometimes they've tried to take shortcuts for good reasons, emergencies, etc. Sometimes they've been impatient with process. And we are a nation that is obsessed with process. I mean, look at all these judicial inquiries. Look how long the Savile inquiry took. Look, things take a long time. So I think the health of our system is under strain because we're quite good at sitting down and working out complex ways of going about things. We're less good at working out a way of getting to the end result. Anybody who didn't listen to Dame Kate Bingham's Romanes lecture should listen to it, because apropos of the pandemic, about her view about how policy is made. As far as Aileen's point that Parliament has shown muscle, Parliament showed muscle. My feeling that parliamentary muscle has been seen only in periods where the governing party is hopelessly divided on some major issue, such as EU membership, or where there is a very slender majority or a coalition, as we saw after 2010. And there are all these wonderful committees, and they produce wonderful reports. And now that I'm back in the sort of more academic framework, we read them and they're absolutely fantastic. But how much impact do they have? I think that is the problem, that we've got parliamentary muscles just going like this, but it doesn't actually cook any beans. It does sometimes, maybe, but I think we need something stronger. And I think my own view is that part of the problem is that if we have a bicameral legislature where one of the chambers has no democratic accountability and is largely appointed by whoever happens, by different majority parliaments, then in itself that's a problem. So I would love to think that we had a strong political constitution. We have it in a crisis, maybe, when people lose confidence in things, but it's not a way of running a country, crisis management. I'm not wild about moving to a written constitution or having a British Bill of Rights, partly because you'd have to work out what to put in it. It would probably take, I think Lord Bingham, in his book, half of the title of which I've stolen, but then he stole it from somebody else. He said it would take half a century to work out what to put in any document. The great advantage of the Human Rights Act was it took an instrument, the European Convention, which we were already party to and had signed up to. And that, I think, is very important, because we didn't have all that. We didn't have constitutional conventions, what have you. But it's very important, because of the open texture nature of the convention, that courts are quite cautious. I do think that Aileen is absolutely right, that you can make an anti-rule of law and certainty case against Section 3 of the Human Rights Act when very, very strained meanings are given, like as happened in some of the criminal justice cases where Parliament decided they wanted a swingeing minimum sentence, and the House of Lords said, oh, unless the justice of the case doesn't require it. And so you had a huge exit from. So I think that my theme of judicial circumspection is very important in that aspect. The Human Rights Act does allow courts to interpret legislation in a way that you would not have thought, those of us who grew up before the Human Rights Act would not have thought was possible. Lord Nichols says that in Gaidan's case. But that's important then not to do that too often, to save it for the right situation and to, as Philip Sale says, to explain very clearly what is justifying this extreme use of language. And I think that is really very important. And I finish by, I quote Lady Hale, who, when dealing with the writings of a former colleague of hers in the Supreme Court, criticizing our courts for deferring to Strasbourg for having a living creature, a living language approach to the convention, she made the point, apropos of prisoners' voting rights, that in the end, if we want to do it, Parliament gets its way. It can't do it by stealth, it has to do it. But in prisoners' voting, we now have different voting systems in England and Wales, in Scotland, and in Northern Ireland. And effectively, the only change that was made in England and Wales was some administrative thing about when people would be, whether they, once they were released on license, they might be able to vote if there was an election when they were on license. So we have got a way, Parliament has a way of having the result it wants. But it must be Parliament, it mustn't just be the executive, which very often means one department with very little parliamentary control. So I think that's the reason for not wanting to go to any written document is also that, as Lord Gough, a great private lawyer, said, the great beauty of the common law is that it develops crab-like. It moves one step here, and then if it's not good, it goes back a bit. And I think that that's quite difficult to do with a written constitution in the way that is envisaged. So I think that things are not terrible, but they have been placed under strain. And they've been placed under strain because people they wanted to do things very quickly, and our culture is one for which we're deeply immersed in process and chewing things over. Enough of me.
Thank you, Jack, and thank you to Philip and to Aileen. It's now over to you. We've got